Hi everyone. Thanks for signing up for the webinar. I can see plenty of people sort of dropping in now. We did have quite a good sign up, so I'll give it a couple more minutes just as people start to arrive. If there's any issues with the technology, if anyone can't see the slides or hear me, then we have got the chat function or the Q&A. So please feel free to drop us a message, but hopefully you can all hear us okay. The session will be recorded and it'll be uploaded to our YouTube afterwards. As I say, thanks to everyone for joining us on a Wednesday lunchtime coming up to Easter. We still find this format works quite well in terms of giving updates, reaching out to our clients. As I said, we have got the Q&A function. We'll try and leave about 10 to 15 minutes at the end. So if anyone does want to drop us a question, then please do, and we'll try and get through as many as we can. Or you'll have our email addresses for coming back to us afterwards. The subject of today's presentation, as outlined on the title slide, changes to the planning system. December's been an interesting time for the last few years. Some might remember the white paper consultation and then the introduction of the standard method, and then the fanfare with the NPPF consultation in 2022. It's probably fair to say that the government upped the ante this winter in terms of actually releasing the changes to the framework shortly after the Levelling Up and Regeneration Act itself became law, and then an innumerable number of consultations since, which I'm not going to pretend I know the count of, but it is still a sort of constantly evolving and or revolving time in the system. So we should have three quite interesting presentations for you today. Graham Free, Associate Director in our Bedford office, is going to deal with the Levelling Up and Regeneration Act itself and some of the associated provisions. I'll deal with a slightly fluffier element on the housing crisis. I'm not going to bore everyone with the changes to housing land supply. I hitched myself to Chris Young's bandwagon fairly early on 4 in 5, and I was right. So there you go. So we'll cover a slightly wider range of topics on the housing crisis. And then Daniel Steadman-Jones from 39 Essex, who Graham and I have both worked with, will give us a legal update on some recent court cases and judgments that have overlapped with, as I say, what is already an interesting time in the system. So without any further ado, I can see a few more people have joined. I suspect, Graham, that a couple of others may well join while we're talking. But if I pass over to your slides and you can take us through the LURA.
Thank you, John. Good afternoon, everybody. As John said, I'm going to be talking about the Levelling Up and Regeneration Act, which is the latest planning legislation aimed at speeding up the planning system. There are, as I'm sure you're aware, mixed views on this, and the key question is whether it actually will speed things up and change the planning system. So the LURA itself then became law towards the end of last year, and as John's already mentioned, it follows the government's Levelling Up white paper in February 2022. So we're told that the purpose of the LURA is to speed up the planning system, hold developers to account, cut bureaucracy, and encourage more councils to put into place plans to encourage the building of new homes. It remains to be seen whether it actually will achieve its aims or just add to the existing barriers and slow housing delivery down even further. Only some of the proposals have become law so far. Many of them will require further legislation. So in many ways, the LURA can be seen as a framework for this further legislation to be introduced at a later date. However, the changes as I set out within it are quite important. So whilst not yet law, it's important to be aware of them in any event. The LURA covers a number of areas of planning. I've listed some of the key provisions there. These are by no means an exhaustive list, but they're what I think are probably the key takeaways from it. And that includes self-build and custom-build housing, enforcement changes, the introduction of national development management policies, the national infrastructure levy, and section 73B applications to vary permissions. The commencement regulations that relate to some of the planning provisions came out at the end of January. So obviously, as of January, the end of January, a whole range of these provisions have been switched on. and that essentially paves the way for them to be formally introduced through secondary legislation at another time. And as I've said, in most cases, the introduction of these provisions just enables the Secretary of State to introduce these changes at a later date. And there's a number of wide-ranging provisions which we're going to talk about, and this could have a number of implications for the planning system. So starting with self-build and custom-built housing then, in my experience when working on proposals for self-build and custom-build, councils quite often, in the past at least, haven't given enough weight to self-build when assessing a planning application. It's always received support in the NPPF, but the LERA identifies some changes in the way that self-build and custom-build are to be treated. I think the key change is that only land that is specifically permissioned for self-build and custom-build can count towards an authority's duty to meet its demand for self-build and custom-build. So in order to count towards self-build, there will need to be a mechanism to secure it as such, such as a condition or a legal agreement, or at the very least, self-build will need to be mentioned in the description of development. In the past, in my experience, some councils have counted planning permissions for single dwellings as self-build, when this has not been mentioned in the description of development and there's been no mechanism to secure it as a self-build. This proposed change would bring this to an end. And this is important because quite often when you're preparing an application for self-build, you may do a Freedom of Information Act request and to find out what planning permissions have been granted for self-build in an area. And quite often councils are counting permissions for self-build which aren't genuine self-build permissions, and this will no longer be possible. So hopefully this will lead to more accurate data on genuine self-build permissions that are being granted in a local authority's area. So far as enforcement related changes are concerned then, firstly there's going to be a requirement to serve a commencement notice before development begins, and this will need to specify the date when development will start on site, and this can be changed once the notice has been served. The idea behind this is that councils can then monitor development that's being done more accurately and estimate the delivery of housing numbers that are likely to be delivered in their area. The LERA also changes the time limit for enforcement action. So the time limit will be 10 years for all breaches of planning control, no longer 4 years. The introduction of enforcement warning notices is also going to be introduced. And this is effectively a tool to allow councils to issue a warning notice where it appears to them that there's been a breach of planning control, and that planning permission may be granted if an application is made. So the notice would in effect make it clear that unless a planning application is made within a specified period of time, further enforcement action may be taken. And in effect, it's a formal invitation by the local authority to submit a planning application to regularise what's been done. It's important to be aware, though, that an enforcement warning notice would stop the clock on immunity. So if you're relying on a 10-year immunity period, for example, then once an enforcement warning notice has been served, the clock on that would stop. So the impact of these potential changes, it may be harder for councils to take enforcement action against minor breaches of planning control. For example, it may be difficult for councils to show that harm caused by a fence or a conservatory or another minor operation that was carried out 10 years ago compared to 4 years ago is harmful. An enforcement warning notice may have some benefit as it has the potential to resolve issues without the need for formal enforcement action. And the issuing of an enforcement warning notice makes it clear that an authority is aware of the breach. But it also provides a mechanism by which it can be resolved outside of a more formal process. An enforcement warning notice may encourage more engagement with developers before proceeding straight to a formal enforcement action. So if you're thinking of applying for a certificate of lawfulness, for example, based on a 4-year period, it might be worth considering submitting it sooner rather than later, and certainly before the 10-year rule comes in. So this is a case study, an example of an enforcement case that I've worked on in Welwyn Hatfield recently. The site was in the Greenbelt. It had a lawful use for vehicle storage, which was granted on appeal in 2001 and then again in 2013. The council then issued an enforcement notice in June last year, alleging a change of use from vehicle storage to a mixed use of vehicle storage, vehicle breaking yard, and the vehicle recovery business within the last 10 years. An appeal was lodged and there was a public inquiry which sat for 3 days. Whilst the council accepted that vehicle recovery and breaking had always taken place on site, incidental to the main storage use, the council's case was that the use of the site had intensified and breaking and recovery were now part of the main primary use of the site. The inspector found that the alleged change of use had not occurred and quashed the enforcement notice, which was good news for our client. However, the case highlights the difficulty with demonstrating that something has occurred continuously for a 10-year period. It also highlights the difficulty with proving that an activity has become more intensive and has gone from being incidental to now being part of the main use. In this case, the council's evidence relied primarily on photographs and records from neighbours and photographs taken by case officers. However, they did not cover the entire 10-year period and instead were more a representative of a snapshot in time. They also did not demonstrate that the activity wasn't incidental. More engagement with owners and occupiers of the site may have prevented the enforcement action being taken. I'm not sure that in this case an enforcement warning notice would necessarily have helped, as the site was Greenbelt and the council probably wouldn't have invited an application. But nevertheless, I think more engagement prior to serving the enforcement notice may have been helpful. So national development policies then, this is a key change that the LURA has introduced. They would sit alongside the development plan and they would have the same weight as the development plan in decision making. The national development management policies would cover more general matters that are important as part of the decision-making process and are applicable to more widely across the country, whereas the development plan would cover more detailed, locally important matters. Where there's conflict between national development management policies and the development plan, this would be resolved in favour of the national development management plan. There would also be an amendment to the wording at section 38(6) of the Act, and the word strongly would be introduced. So it would read, decisions should be made in accordance with the development plan and national development management policies taken together, unless material considerations strongly indicate otherwise. This is important as it indicates a higher bar is required to depart from local or national policy. And the purpose of national development management policies, I think, is to remove many of the generic policies that we find in local plans that are the same across the country, and to try and remove any duplication between local and national policy. The infrastructure levy, again, another significant change that's been introduced. This will replace section 106 and also the community infrastructure levy. And it's described as a non-negotiable levy, which enables local authorities to raise money from development to regenerate their areas through infrastructure. It would replace all financial contributions currently dealt with through section 106 agreements, and affordable housing contributions would also be dealt with through the infrastructure levy. The rates would be set locally by local planning authorities and not nationally. And importantly, and a difference from the community infrastructure levy, the levy will be based on the final gross development value of the development. There is some concern within the industry on the new infrastructure levy. And this includes the fact that it may create uncertainty at a time when there is a need to build more homes. And also the way that it's to be calculated is fairly complex, and this could be difficult for councils to resource. My initial thoughts on this are whether it would actually deliver the affordable housing at the rates needed, which could impact on the delivery of affordable housing. And also the fact that it's based on development value may make it difficult for developers at the initial stages, at least, to work out what the infrastructure levy of their scheme would be, and therefore whether the scheme would be viable in the first place. And as with much of the LURA, this requires secondary legislation to come into force. Section 73B applications. Again, this is a significant change that has been introduced by the LURA, and it's the introduction of a new power to amend planning permissions. Again, it's not yet been brought into force and requires secondary legislation. It's been introduced in response to the Finney judgment that some of you may be aware of, that ruled that amending the description of development is outside of the remit of Section 73 applications, which is the route many of us have become used to. Section 73B will allow a local planning authority to grant a new permission where its effect will not be substantially different from the existing permission. It's similar to the Section 73 process in so much that the council can only consider the difference between the new proposal and the existing planning permission. They can't reopen other matters of principle that have already been established. Again, and typical for planning, there's no definition as to what substantially different means. So like the current non-material amendment process and minor material amendment processes that we have, it's a planning judgment to be made on a case-by-case basis. However, I think Section 73Bs may allow for a broad range of changes to take place, so it may offer greater flexibility for the planning system than the current Section 73 process. Some of you may be aware that there's been a consultation published recently on an accelerated planning system. It was launched on the 6th of March, and it proposes a number of changes in an attempt to speed it up. The consultation closes on the 1st of May. The number of measures that are proposed, and some of these include quicker decision making for major commercial applications. So this would mean a target date of 10 weeks instead of 13 weeks. There will be a higher application fee to pay, but the application fee would be refunded if the local authority does not meet the timescale. Changes to the extension of time process. It's proposed to introduce a new performance measure related to the speed of decision making. So there would be performance thresholds would be introduced. So it's proposing at this stage 50% of major applications to be determined within the statutory period and 60% of non-major applications to be determined within the statutory period. And the idea is to discourage the use of extension of time, agreements, and they would only be used in exceptional circumstances. And then the other proposal is the more simplified process for written representation appeals. So the proposal to expand the current householder appeals process to written representations appeals. It would only apply where an application has been determined, so it wouldn't be used for non-determination appeals or enforcement appeals. There would be no opportunity to submit additional evidence or to amend proposals, and there would be no opportunity for third-party comments, and local authorities would need to rely on their officer report. And the other proposal that's being consulted on is the Section 73B route to barrier permission, as I've just mentioned previously. So will the proposals that are being set out in the consultation on the accelerated planning system actually make any difference and speed things up? I think in relation to the quicker determination process for commercial applications, there's a risk that in an attempt to issue decisions on time, councils may just refuse applications rather than negotiate to resolve any concerns or issues that may arise. In terms of the simplified written representations appeal process, this may mean that councils need to think about writing more detailed officer reports that they can rely on at appeal if there isn't going to be an opportunity for them to submit more detailed appeal statements, as the case may be for the appellant. And thirdly, in relation to the absence of third-party comments for written reps appeals, this may in fact speed things up, as there wouldn't have been no opportunity to, or no need to, comment on third-party representations that have been made. So thank you, John. I think that's the end of my presentation on the LERA, and I'll hand back to John.
Thanks, Graham. A brief plug for the Q&A box, if everyone else can hear me okay, before I take us on a whistle-stop tour through the housing crisis. The subject matter I'm going to cover here is just set out on the first slide, and yeah, a bit of a plug for point 3 really, which sets out some of our own research. But in terms of national policy, I thought I'd almost go back to the first of our significant Decembers, which is December 2020, when the government basically told us that they were sticking with what we still call the current standard method, 2014 based projections, warts and all, and 300,000 homes remains the government's ambition for house building. I think it's interesting the bits that I've underlined here in terms of their response, in the sense that that did give us a few indicators that we were also going to be sticking with the current national policy and guidance that we have for housing, which actually seeks to emphasize a number of the benefits of housing delivery that are much wider than simply that 300,000 homes figure. But some of the things that I think the government knew and knows they need to do within that figure in terms of what that housing delivery should mean in terms of different challenges, such as older persons housing, family housing, and affordable housing, which I think we've all got interests within. And where's that left us? Well, we're certainly not solving the housing crisis. The government remains committed to that 300,000 figure. And I think the point is that the government hasn't actively set out to worsen matters in terms of what national policy says for housing. And I think you can see that in terms of some of the wider changes to both the plan making system in terms of sort of retaining the justified test and retaining the standard method full stop. But the reality obviously has been somewhat different when you look at the wider context for those changes and the reality that we've seen in terms of delays to local plans, and the concern that certainly filters down to at the local level, in terms of, has the government actually changed its ambitions on housing delivery? I think that becomes a far more nuanced and controversial point. When we actually look then at changes to the National Planning Policy Framework, I think it's interesting that you can see some of the key headlines that I've set out here. The December 2023 changes, although there was much fanfare in the consultation a year previously that I alluded to in the introduction, we haven't, in terms of housing policy in itself, seen a fundamental shift. That becomes a slightly different question when you look at it as the overall mixed bag, including particularly changes to Greenbelt policy, and as I say, some of those areas where it becomes far more locally nuanced. The issue really is in seeking to meet as much housing need as possible, where the standard method remains the starting point. Will the government's proposals and their overall effect on housing delivery, will it take us forwards or backwards in terms of the ability of providers to meet the different range of priorities, where the government has placed some more emphasis within the changes, not least specialist housing for older people, as Graham alluded to, support for self-build and also support for community-led development. It hasn't really made any changes to support for large-scale strategic development, which remains there in national policy, but is most likely to be impacted by the delays to plan making that I alluded to a second ago. And alongside that, what we have got is the support enshrined now for the Urban and Cities Uplift. That ties us into the 300,000 figure in the way that it's arrived at through the standard method. And there is encouragement for authorities that want to exceed the standard method, again, importing some of the planning practice guidance into the framework. The circumstances where authorities may look to go below the standard method, again, are also now set out in the framework, but the way in which they're to be approached in terms of exceptional circumstances and specifically having regard to demographic change means that really nothing should have changed in how you actually assess housing need. And what we all know, which I think is a very wide range of housing needs that we should be meeting as part of those assessments. With that being said, there's always time for Alan Partridge. Whether the government really wants evolution or revolution and what it actually wants the effect of its changes to be, I think then gets somewhat more muddied by the changes to the further consultations that are proposed or underway and as set out on this slide. Again, really arising out of the government's review of the London plan and the comments of Chris Katowski. There's a question really as to why a presumption in favour of sustainable development on previously developed land would really only apply in the 20 largest urban authorities. And is it also going to make much difference when they're so far away from meeting their urban uplift figure anyway? And also, in terms of giving as much weight as possible, well, giving significant weight to the benefits of delivering as many homes as possible on previously developed land, whether there are potential cross-cutting effects there or unexpected consequences. I mean, will that be bound up in terms of some of the other NPPF changes, for example, on protecting the character of suburban areas? So it sort of shifts the dial probably away from some of those larger ambitions of house building. And inevitably there will be challenges for focusing development on previously developed land that are less difficult to or less easy to achieve with a focus on those locations. And I think, again, although there are now more protections in terms of what permitted development rights can provide, removing the 1,500 square metre threshold on Class E, including office to resi permitted development, might have a short-term impact on overall numbers, but you might say moves us somewhat further away from that aim that was actually outlined in December 2020 in terms of the types of houses we should be looking to provide. And just briefly on this slide really shows us where we are in terms of the reality. Permissions have been falling, completions have been falling. So the ambition might still be there and the national policy might be fundamentally unchanged, and how we should be assessing that need might be fundamentally unchanged. But what we're achieving in terms of the overall context for output and permissions isn't looking like an entirely rosy picture at the moment. And I think you can pin some of that to uncertainty in the planning system, much as you can pin some of it on the wider political context and wider economic context as well. I think what that means, I should probably put these in a different order, from the humble granny annex through to the retirement village, through to the large-scale urban extension. The government's not giving us a lot of clarity on what they think solving the housing crisis should look like, but we have still got all those building blocks with us. And what we've been doing, moving on to the, if you like, the positives, or where I think we all should be telling a bit more of the story that there are genuine positives to housing delivery, and there has been housing delivery. The initial headlines from the census has been out for about 18 months now. Most of the headlines are concerning in terms of adult children living at home with their parents. Many will have seen our briefing note on fertility rates, indicating that they probably are impacted by what we have seen, which is a decline in home ownership in terms of those owning, in the process of buying their homes effectively with a mortgage or via shared ownership. And it's interesting that the only positive growth in ownership with a mortgage has been in the shared ownership category. It's been offset. That's helped offset what would otherwise be an over 500,000 household decline since 2011, which does seem rather contrary to some of the government's stated ambitions. So when you, I mean, I'm a super fan of the census. I won't make any apologies. Whether they repeat it next time remains to be seen. I'm not sure that there's as much emphasis being placed on making sure we do another census in 2031. The logic of doing one is strong, given that the 2021 iteration was undertaken in the pandemic. But we really should be using that data to, I think, tell a positive story of house building. It will be applied to inform policy and help to run our services for the next decade. So understanding it is critical in my view. And one of the ways we tried to understand it, and there was initially a suggestion that the government, or the Office for National Statistics on their behalf, was going to undertake some of this work as well. We have built homes, and it's not the role of the census to directly tell us what the impact of new development has been. But the way in which the ONS runs the geographies for the census is that where you have had large-scale development, you can identify that by looking at output areas used in the census, particularly the new ones, where they correlate with a high number of new addresses. The ONS had said they were actually going to drill down into some of the specific characteristics of households within new development, and I think that's what they meant. And they've since changed their analysis plans to say that you're not going to get any more, which I think that's a bit negative. I mean, clearly there is a role for the census to be objective rather than political, and I can certainly see why that analysis would have become slightly political for reasons I'll show you for the next couple of minutes. This is a map that I really quite like. If everyone can see, it might be difficult, and we can share the slides afterwards, but it shows you those areas, typically around some of our main patch, where more than 30% of the addresses are new since the 2011 census. So it shows you some of those strategic expansion areas like Eastern Milton Keynes and Wixham's in Bedford. And I don't know, maybe it's just me, but I think the fact you can show that from the census is really cool. What does that then tell us in a way that possibly no one else will without undertaking this analysis of the census outputs? The work that we've done is to group those output areas where more than 30% of the addresses are new since 2011. In reality, that is generally new output areas, so it's often a much higher percentage than 30% of addresses that are new. And you can see very quickly that within those areas, that's where we're still achieving a boost to home ownership with a mortgage. And we're achieving very significant boosts to delivery of shared ownership, looking much like your typical proportions in affordable housing policy and Section 106 agreements. A totally different situation to the totals of authorities. And again, this example being Bedford, where you've got very high percentages now of homeowners owning outright outside areas of new development. And again, that correlates generally with an aging population, lack of turnover in the market. Some interesting observations on average household size, which do have implications for infrastructure provision in Section 106. You can see very high average household sizes in these areas. Generally speaking, they're not mixed communities in the same way that you'll see in a larger existing area, and you will see a high proportion of dependent children in those areas. It's also the case that where we've delivered large numbers of shared ownership units, they correlate with the areas that have had relatively successful rates of large-scale development, and you will find those shared ownership units within those areas of new development, and that's the only way which we've actually boosted affordable home ownership within the last decade. As soon as you look at that sort of at the local authority average, even in those areas we've looked at with higher rates of house building, you'll find low levels of shared ownership that generally just look like the local authority's position. You basically find the concentration, you find the growth in areas where you can identify that new development has taken place. So what does that mean in practice? Well, I think it shows us that benefits of development do exist and that the impetus on development should still be there. I won't be an apologist for strategic planning to say that you will identify the same benefits at the small scale. It's very hard to find those within the census, but clearly all new build development is having some of those positive outcomes that you wouldn't otherwise get in terms of particularly boosting home ownership and boosting affordable housing supply. There are implications for plan making and infrastructure provision where we look to achieve that at scale. They should all still be parts of the new system, really. And whether the governance changes are actually looking to keep us on track with those overall ambitions and benefits of house building, I don't think they've fundamentally moved away from recognising those benefits, but I do think that constant, threats of revolution in the system haven't necessarily provided the stability to keep up the levels of output that we know we need. So if anyone wants to drop me a line on the research or areas that you've been involved in developing, then please do. We can always look at that in the context of things like housing mix statements and housing need assessments. So with that in mind, I'll pass over to Daniel for the final part of the presentation.
Thank you very much for those useful observations and insights, Graham and John. Slightly alarming to see the fresh-faced former me in my photograph there. I must get a new photograph done. But good afternoon, everyone. I'm going to focus today on planning case law. There have been a flurry of quite important recent decisions, many more than I can deal with today. So there's a lot going on in the courts as usual, but in particular, the last few months have been quite significant. My focus today is on 4 cases, actually. The first 2 concern important developments in policy, and the second 2 relate to the continued fallout, if I can put it that way, from the Supreme Court's judgment in Hillside from 2022, which I'm sure many of you are aware of. Dealing first then with policy, there have been 2 big cases recently, which I'm sure many of you have probably noticed, but if you haven't, the first was Marks and Spencer's, which was handed down at the beginning of the month, and the second was Mead Realisations and the Secretary of State, which was handed down in February. Turning first of all then to Marks and Spencer's, there is a picture of Marks and Spencer's as it stands today. The case concerned the long-running battle, which again I'm sure many of us have followed, for the future of M&S on Oxford Street. There's a picture of the proposal, which has been widely praised and approved for its design and for its look. Of course, objectors disagree with that. But as I say, this has been a very long-running battle, and the key question for the developers and the councils and the objectors is whether there should be a refurbishment of Oxford Street M&S, or whether it should be demolished and rebuilt. Initially, the local planning authority, Westminster, granted permission, but the Secretary of State called in the application, and an inquiry was held. There were objections largely on heritage grounds, but also involving issues around net zero and carbon impacts in particular. Save Britain's Heritage was a Rule 6 party at the inquiry, and the inspector hearing the inquiry and the evidence recommended approval, and the Secretary of State in a subsequent decision letter overruled and refused permission. And then we had the Section 288 statutory challenge to the Secretary of State's decision, and that came before Mrs. Justice Leven. So there were 6 grounds of challenge brought by Marks and Spencer's to the Secretary of State, Michael Gove's decision. The first ground concerned paragraph 152 of the NPPF and its meaning in the context of the application. The second concerned the treatment of alternatives. The third ground related to the balance of benefits and heritage impacts. The ground 4 related to the question of harm to the vitality and viability of Oxford Street within the Central Activity Zone, within the CAS. Ground 5 related to the nature of the carbon impacts and the proper interpretation of London Plan policy in relation to carbon impacts. And ground 6 related to heritage. Grounds 1 to 5 were successful, and it's fair to say that the Secretary of State got a bit of a roasting in the judgment. I'm going to just draw out in particular grounds 1 and ground 5. Grounds 2, 3, and 4 related to reasons points, and as I say, they were upheld. But in particular, or of most interest, I think, are grounds 1 and 5. Now, ground 1 relates to paragraph 152, which is now 157 of the NPPF. And as we know, this paragraph provides for a pretty high-level statement of policy aspiration or aspirations for the transition to net zero and the transition to low-carbon future. The court held that the Secretary of State had wrongly agreed with a comment by the inspector in his decision in the recommendation report that this policy constituted, among other things, a presumption that in favour of the reuse of existing resources and conversion of existing buildings. Now, Mrs. Justice Leven said that this was wrong. This was an error which flowed through into the other grounds or the other issues in the case and throughout the Secretary of State's decision letter. Mrs. Justice Leven, in addressing this point, made clear in paragraph 55 that she didn't consider this to be a presumption. Rather, it's a paragraph which, as she says, refers to a number of other very general policy aspirations, including the importance or the encouragement for the reuse of buildings. And she said there's nothing in the paragraph that supports the application of a policy presumption for one part of that paragraph alone. And at 56, her conclusion was that the Secretary of State has not applied the policy, but he has rewritten it. And that this then led him to applying a test or a policy hurdle throughout the rest of the decision letter, which was based on that misinterpretation. Importantly, just before I come on to ground 5, the presumption, we know from the NPPF that where presumptions are, there are presumptions, most obviously in paragraph 11, also a presumption of sorts in relation to Greenbelt policy, for example. Where presumptions are present, they are expressly stated or made very clear in any event, even if the word presumption is not used. And so Mrs. Justice Leven was pointing out that the Secretary of State is not entitled to change policy by attributing a meaning to a particular policy, which just doesn't, it cannot have effectively. The second important ground, I think, from the Marks and Spencer's case in relation to the Secretary of State's errors, according to Mrs. Justice Leven, related to embodied carbon. Now, the issue here, there were two elements to this ground. One was that there had been an error of fact in the Secretary of State's decision by stating that there wasn't a significant dispute over the issue. That was wrong, as a matter of fact. But perhaps more interestingly, there was an error of policy interpretation. And in particular, there was a confusion on the part of the Secretary of State in the decision of whether London Plan Policy S12 C related to operational carbon or embodied carbon. Now, the Mrs. Justice Leven said that it was impossible to say that part or that limb of the policy related to embodied carbon, and that the Secretary of State had become thoroughly confused. So quite harsh words for Mr. Gove. She described that the Secretary of State's approach as, and in particular defence of the approach, as an impossible submission in the court, and that it was a transparently wrong interpretation. But the saga will rumble on, because ground 6, although heritage was clearly one of the most important issues probably in the case, and that ground was upheld, or rather Mr. Gove's decision making in relation to it was upheld albeit that Mrs. Justice Leven did describe the reasoning there as somewhat surprising. So we're going to have to watch this space to see what happens on once the decision is remade or remitted for further consideration. And no doubt there'll be further instalments as we move forward. So I don't know if anyone's ever wondered who would win in a fight between the NPPF and the PPG, but the court has given an answer, perhaps the clearest answer yet, on that question in the recent case of Mead Realisations. Now, this was an important case both in terms of the interplay of the framework with the planning practice guidance, but also in specific terms on policy in relation to flood risk and the sequential test. There were 4 grounds here. One was the interpretation or the proper interpretation of paragraph 162. The second was whether the PPG can change policy and particularly change or limit or constrain the application of paragraph 162. The third ground related to the interpretation of that part of the PPG. And the fourth ground related to the question of need for the development and how that should be approached when alternatives are being considered under the sequential test. The challenge failed before the planning liaison judge, Mr. Justice Holgate, and the court gave guidance on policy, important guidance on policy. So that's paragraph 162, and the case really related to the underlined part of that paragraph there, what reasonably available sites appropriate for the proposed development in areas with a lower risk of flooding means. Sorry, John. Yeah, thank you. And then paragraph 28 seeks to define what reasonably available sites are, and it sets out there what they are meant to mean, and also includes the following passage that they can include a series of smaller sites or a part of a larger site. Now, I should have added there that there is a third limb to that part of the PPG, which relates to 5-year housing land supply, and that was one of the issues in the case as to whether those kinds of more general overriding needs, if I can put it that way, would be relevant parts of the consideration when decision makers are considering the sequential test. So Mr. Justice Holgate gave some important guidance on the PPG. At paragraph 59, he started really by re-emphasising principles with which I'm sure most of us are familiar. The first is the proper, the nature of material considerations, the primacy given to the statutory development plan, albeit that, as Graham says, that's going to have slightly shifted soon with the introduction of national development management policies. But certainly for the moment, the primacy in planning law of the statutory development plan. And then, of course, the weight to be given as a matter of judgment for the decision maker in planning balances and the likes, and the fact that those types of planning judgments can only be interfered with on public law grounds. So those are all well-trodden principles. But he went on at paragraph 70 to say that as a matter of policy, the planning practice guidance, while it's intended to support the NPPF, and ordinarily they will be compatible, he concluded, I see no legal justification for the suggestion that the Secretary of State cannot adopt planning practice guidance which amends or is inconsistent with the NPPF. So this is quite a striking conclusion, and I think surprising to many of us, not least previous judges such as Mrs. Justice Leven in the Solo retail case, for example, and Mr. Justice Dove also in an earlier Menston Action Group case. Both of whom had assumed, I think, like many of us, that because of the consultation and the detailed preparation that accompanies the NPPF, that there would be a distinction between the two, and that the NPPF would take, as it were, precedence over the PPG. But Mr. Justice Holgate was unimpressed with those arguments, and he emphasised rather the accountability of the Secretary of State to Parliament, and also the Secretary of State's role coordinating and overseeing the planning system. And in the process, he pointed to the precedents of policy changes which are often made without consultation for example, the written ministerial statements or indeed PPG updates, which can come in, certainly as we know, without consultation. So alongside the sort of principal point on PPG and PPF, the court also interpreted flood risk policy. Now here again, we had a restatement, I suppose, of some sort of basic principles, I suppose, in planning. The first point was that there should be flexibility and realism in the application of sequential approaches. Of course, we've got the sequential approach to flood risk. We've also got retail sequential tests and so on. Now, really, the judgment emphasised the importance of judgment for the decision maker in the application of the policy. It was a matter to weigh up the concerns that were relevant, but he did go on to say that certain considerations would be relevant and certain wouldn't. So, specific need, i.e., the specific need for the type of development that's being proposed, would be relevant, but it wouldn't necessarily be determinative. And of course, and also Mr. Justice Holgate pointed out that it wouldn't just be specifically, it doesn't need to be so specific to the type of development proposed by the developer that other similar developments could not be considered as potential alternatives. But that would be a matter for the decision maker in a particular case. Issues of general need and the issues of whether it's satisfying a particular general need, such as, for example, a 5-year supply shortfall or a 4-year supply shortfall, as we now must think about it, would not be relevant to a sequential type assessment. Those types of general overriding needs should be considered as part of an overall planning balance instead. And he concluded that it follows from his judgment that paragraph 28 of the PPG doesn't conflict with paragraph 162 of the NPPF, and that the PPG performs the legitimate role of elucidating what is an open textured policy in the NPPF. So turning then to the fallout from Hillside, I'm sure, again, many of us sure all familiar with the Hillside judgment by now. That judgment came out from the Supreme Court in 2022, and it reaffirmed the old Pilkington principle, and that is that the implementation of later planning permission, which departs in a material way from an original scheme that would make it physically impossible, and hence to carry out any further development under that original permission. The courts have begun to consider the fallout from this, and in a sense, it was an example of the courts dragging planning practice back, I suppose, to principles which are actually old but not often honoured. Planning practice had perhaps advanced beyond what the law properly understood allowed. So the first case I wanted to deal with was Dennis. Now, this was a challenge to the decision to grant a Section 96 application for an amendment of a phased outline planning permission in Southwark on the Aylesbury estate. The issue was whether a phase of the planning permission was severable and so came outside or could be brought outside the Pilkington principle to keep the original permission alive. Now, the local planning authority officers, concluded that the phase was severable and that the drop-in application wouldn't prevent the remainder of the planning permission from being developed. They were minded to grant that drop-in application, but only subject to the Section 96A application, which would, it was hoped, as a sort of belt and braces type approach, clarify or make certain that the original permission was severable. The issue for the court in Dennis was whether that amendment was material or not. So Mr. Justice Holgate said that Hillside and Pilkington, or rather Hillside had held that Pilkington did apply absent a clear indication on the planning permission or in the planning permission, and that this was ultimately a matter of interpretation of the planning permission. So it was a classic matter of the construction of the planning permission, looking at it in the round and seeing what it permitted. Mere phasing was not sufficient, he said, to displace the Pilkington principle. And it didn't matter whether it was an outline or a full planning permission. It was an issue of, as I say, interpretation of the planning permission. Did it, in fact, create separate planning permissions? The answer in that case was that it didn't, and just because it was phased doesn't mean it's severable. In fact, being phased is entirely consistent with it being a full integrated permission. Sorry, I've just lost my screen. Sorry, John, can we go back to the previous slide? Importantly for practitioners and for developers, severability might lead to unforeseen consequences, and so in particular, developers need to consider whether they want to advance the argument that a permission is severable. And in particular, Mr. Justice Holgate mentioned time limits as a potential problem, and the bundle of rights that might be associated with a permission. And if in fact, as in this case, that the bundle of rights associated with the planning permission were expanded, then it could not be said that this was not going to be a material amendment. But fundamentally, the decision of the court, if you like, was that it was important that any decision to grant a severed planning permission is expressed unequivocally. So turning to the second case, concerning hillside principles, Fisk. Now, there's been a number of Fisk's cases. It's again another on-running saga, but here the claimant challenged the grant of planning permission for a solar park development. Now, there had been two permissions, one in 2017 and one in 2021. They were both for solar park development, but they were different proposals. But the 2021 application and permission was expressed to be associated with that 2017 permission, and the claimant or the appellant had brought a challenge on the basis that it should have been considered by the officer and the planning committee ultimately that there was an incompatibility between those two permissions, and that this was a mandatory material consideration. And you'll remember that material considerations are either those that are capable of being considered or those that must be considered. So the claimant and the appellant in this case was arguing that that incompatibility between those two permissions had to be considered and had not been considered by the planning committee. But here the answer was pretty straightforward, and again, a restatement of old principles, really. The planning system allows for multiple planning permissions on a site, and there's nothing wrong with that, as Pilkington had already established. And ultimately pushing it back again to the developer to decide upon and resolve incompatibility when deciding how to proceed with future applications. So we have both in Dennis, we have a warning from Mr. Justice Holgate pointing out that developers need to be very careful about how they're going to address any hillside or drop-in application type issues. And here in Fisk, we have the same principle being emphasised really by the courts, that the developer needs to make the decisions about what they want to do, and that it's not for the local planning authority to anticipate those possible avenues open to a developer, nor is it a responsibility for the local planning authority to assist in that process. Although, of course, we know in practice that sometimes local planning authorities will be more or less positively minded towards particular proposals. So thank you very much for that. And I'll perhaps we can throw it open, John and Graham, in case there are any questions or anyone or any thoughts that we should be discussing.
Yeah, thanks, Daniel. Thanks, Graham, as well. Yeah, I've not seen any questions pop up yet. So if anyone's got anything burning, we're happy to sort of hang on for a good 10-15 minutes to address anything that comes up. Or likewise, I suppose, Graham, possibly a question for you in the first instance. Obviously, we've got the commencement regulations. There's still a number of parts of LERA still there in the background. Are there any that you think are sort of most significant that a government of any colour, given that there might be a change on the horizon, could end up grappling with in terms of provisions that are yet to come into force?
I think from probably the main ones which I think are probably significant are the infrastructure levy, because that presents difficulties, I think, for both local planning authorities from a resource perspective, but also for developers from a viability perspective, and knowing what the levy is likely to be before they embark on their proposals. The other one, which I think might be interesting, is national development management policies, exactly what they might look like, but also if and when they do come in, consistency in interpretation between different local authorities, whether they're going to be interpreted consistently across the country. It will be, I suppose, in much the same way as we have with the framework at the moment. It'll be interesting to see how that plays out. I think the problem with the LERA generally is that it's vague, as we know. It lacks detail, and in some respects it perhaps creates some uncertainty, particularly with sort of the infrastructure levy and other provisions, leaving much of it to secondary legislation. So it's sort of while some of it is welcomed in terms of trying to address the housing crisis, there's a lot of unknowns still.
Yeah,
just chipping in on that, John. I mean, I think we know from, I mean, partly from the Mead Realisations case as one example, but we know that this is likely to generate some uncertainty, and certainly in the courts, it's probably going to generate some activity. The interrelationship between NDMPs and the development plan, and quite what that means for the supposedly plan-led system and so on. And of course, it's intended to create a big shift. But working that out in the detail is going to be interesting. And Graham, you're right, of course, that there is a whole load of needless replication and duplication across between plans and the NPPF and all of that, which is, you know, it's eminently sensible to get rid of all that. But on the other hand, it may well be that there'll be inflection points where there's going to be significant divergence or possible divergence, and it's going to be interesting to see how that plays out, isn't it?
Yeah, that's right. John, just picking up on some of your slides and your presentation, what, if anything, do you think may have changed in terms of putting together evidence for housing need and those types of proposals?
Yeah, it's a good question. I think certainly in terms of the tenders that we've seen so far, those that have been released since December, very little's changed at the moment. Your local housing need assessment, we've still got the associated planning practice guidance that covers effectively all the different priorities for need that we touched on today in terms of affordable housing, family housing, needs for older people. So the basic framework of your housing need assessment hasn't changed. They were already becoming more complex due to grappling with things like first homes that was introduced best part of a couple of years ago now. The number of authorities that are grappling with the exceptions to the standard method, again, seem to be very limited. I know Swale, we picked up and put out a tender to that effect, seem to be pretending they've got a bridge, or maybe that's going into their infrastructure delivery plan, I'm not sure. But again, you would still expect an authority to grapple with that in what the NPPF now tells us in terms of, well, it remains about meeting as much housing need as possible. And I think in terms of the demographic justification for any departure from the standard method, you'd actually need to understand what its implications are for all your elements of housing need before going, well, actually, we're an exception to it and we're going to depart from it. And this is what it means in terms of our delivery. And, you know, by implication, any step away from the standard method is going to move you away from meeting homes in accordance with the 300,000 objective of the government, because that's how we get there, from effectively adding up the standard method figures. So you would hope, because we've retained the justification test and because we've retained the parts of national policy that are fundamentally unchanged, you wouldn't expect a major difference in terms of how that should be assessed rigorously at examination. That might obviously get bound up in terms of changes to the new plan making system for anyone that goes post 2025, post July 2025, and that kind of comes back to your LURA presentation, I think, Graham. The final bit to probably pick up on is the older person's housing need topic. Now you've got a specific reference to that in national policy. You'd expect it to be a bigger part of local plan making, in terms of, you know, giving due weight to the critical importance of that need. Whether that actually translates into an accurate number or an objective number in evidence base, and then whether it actually translates into allocations in plans, are two very different things. But I think that's probably the element of the housing need assessment that should be translating into a genuinely higher proportion of authorities' housing requirements if we're going to achieve those added benefits of, for example, freeing up family housing. But that's already there in most housing need assessments. As I say, actually delivering it in practice and in adopted policy is a very different challenge. So again, the extent of change is kind of limited in that regard.
Yeah.
Daniel, if we've still got no questions, I've got one for you, which might be a bit of a risk of a curveball, and it's a personal observation really on the Marks and Spencer's case. My understanding is that will ultimately require submission of a fresh application now, rather than redetermination of the quash decision letter. Is that your understanding? Does that tie into just basically the length of time that the case has been running for, and because the heritage ground was upheld, or have you got a different view on that?
I hadn't heard that. I mean, I thought that it was going to go back. I mean, obviously, I suppose it's ultimately a matter for the developer to decide what they want to do. But it seems to me that the application is defensible. I mean, the point on the heritage, I mean, there'll need to be some amendment, I would have thought. So whether that amounts to a full new application and then start the whole process again, I'm not entirely sure. Certainly the heritage matters, as you say, or as I said, you know, they have been upheld, albeit that, as I say, Mr. Justice Lieven expressed, well, said that they were surprising conclusions of the Secretary of State. I mean, the usual thing would be that you go back and you have to consider the aspects of the decision that are, you know, the aspects that need to be reconsidered, as it were, from the decision. But because it's been quashed, albeit that his findings, Mr. Gove's findings on heritage were not themselves criticised, or rather, the court said that he was entitled to find what he found. The whole decision letter has been quashed, and that's partly because the way in which the error was made on carbon, for example, flowed through the whole decision. And so you can't, nothing survives from it. So the question is going to, I would imagine what's going to happen in the first instance is that there will be, whether they reopen the inquiry or whether there's just, I suspect the Secretary of State will take the easier option of asking for written submissions, whether that is what happens, or whether the claimant in particular is successful in reopening the inquiry. I suspect, unless the developer rethinks and thinks, well, I'm just going to submit a new application, what's more likely to happen is there'll be a round of written representations, and then Michael Gove will remake a decision, probably with his potentially with similar heritage findings, and then you know, kind of reconsidering, if you like, the rest of the other issues which were criticised in the judgment.
Let's still wait and see then.
Yes, I think so.
So we've had sort of 10 minutes post the presentation. We will we'll circulate a copy of the slides around, and as I say, the recording will go up onto YouTube. If anyone does want to drop us queries afterwards, then please do so by email. We will aim to get back to you. And yeah, we're pleased we've been able to put this on. Hopefully that brings some clarity at quite a chaotic time in the system. We will no doubt look to organise another one. Both Graham, Daniel, and myself have probably steered clear from most of the political points, but we may well find they're part of the planning calendar in the next 6 months, and ultimately have a further bearing on what we're going to be saying in future presentations. So yeah, with that in mind, I'll stop the webinar. But again, thanks everyone for joining us. I haven't seen any last minute questions. So unless Daniel or Graham have got anything for me, yeah, be good to see you all, and yeah, we'll circulate soon.
Thanks, everyone.
Thank you. Thanks, everyone.